Okay.
Text me if you want me to do anything.
Thank you for holding. We look forward to talking with you soon. Please hold the line. We'll be right back with you.
Thank you for holding. We look forward to talking with you soon. Please hold the line. We'll be right back with you.
Thank you for holding. We sincerely appreciate your patience. Please stay on the line. We'll be back in a moment.
Thank you for holding. We sincerely appreciate your patience. Please stay on the line. We'll be back in a moment.
Thank you for waiting. Your patience is appreciated. Please hold the line. We'll be right back with you.
Thank you for waiting. Your patience is appreciated. Please hold the line. We'll be right back with you.
Thanks for holding. We appreciate your time and patience. Please stay on the line. We'll be back in just a moment.
Thanks for holding. We appreciate your time and patience. Please stay on the line. We'll be back in just a moment.
Thank you for holding. We look forward to talking with you soon. Please hold the line. We'll be right back with you.
Thank you for holding. We look forward to talking with you soon. Please hold the line. We'll be right back with you.
Thank you for holding. We sincerely appreciate your patience. Please stay on the line. We'll be back in a moment.
Thank you for holding. We sincerely appreciate your patience. Please stay on the line. We'll be back in a moment.
Thank you for waiting. Your patience is appreciated. Please hold the line. We'll be right back with you.
Thank you for waiting. Your patience is appreciated. Please hold the line. We'll be right back with you.
Thanks for holding. We appreciate your time and patience. Please stay on the line. We'll be back in just a moment. Thank you for holding. We look forward to talking with you soon. Please hold the line. We'll be right back with you.
Thank you for holding. We sincerely appreciate your patience. Please stay on the line. We'll be back in a moment.
Thank you for waiting. Your patience is appreciated. Please hold the line. We'll be right back with you.
Thanks for holding. We appreciate your time and patience. Please stay on the line. We'll be back in just a moment. Thank you for holding. We look forward to talking with you soon. Please hold the line. We'll be right back with you.
Thank you for holding. We sincerely appreciate your patience. Please stay on the line. We'll be back in a moment.
Thank you for waiting. Your patience is appreciated. Please hold the line. We'll be right back with you.
Thanks for holding. We appreciate your time and patience. Please stay on the line. We'll be back in just a moment.
To join a conference now, please enter a meeting number followed by pound. If you are the meeting host, please enter your PIN. Otherwise, press pound to continue.
Thank you for holding. We look forward to talking with you soon. Please hold the line. We'll be right back with you.
Thank you for holding. We sincerely appreciate your patience. Please stay on the line. We'll be back in a moment.
Thank you for waiting. Your patience is appreciated. Please hold the line. We'll be right back with you.
Hello? Good afternoon.
Hello?
Hello? Yep,
Hi.
hello, it's Lucas.
Thank you for your patience. This is Magistrate Wheeler, and I have just videoed into the jail. Good afternoon to the jail.
Good afternoon.
Who do you have available?
I have Gola, totally, ¿qué es su nombre, señor? ¿Su nombre? José Armando Mendoza. ¿Qué?
Jose Armando.
Mendoza.
And you have Armando Mendoza, Golat, Tosley?
Yes, that's what I have right now.
Okay, and is there anybody from the Public Defender's Office on the line for Armando Mendoza?
Yes, Your Honor, Corey Stone is present from the Public Defender's Office.
Good afternoon, Mr. Stone. Were you able to speak with him, or would you like the court to call the case up and the interpreter's here and you can have a few moments to speak with him?
I was able to speak with him, Your Honor.
Okay. Then I will call, the interpreter is present. I'll call Jose Armando Mendoza, 20 CR 1715. Good afternoon, sir.
Hola, sorry.
I'm Magistrate Wheeler, and on the phone is Public Defender Corey Stone, who talked to you earlier, and also... And from the District Attorney's Office, please enter your appearance.
Corey Stone for I apologize, Your Honor. Corey Stone for Mr. Armando Mendoza. He's been advised of the charges and of the possible penalties. We would ask to waive any further reading of the advisement and of the complaint. One issue, Your Honor, if the people could perhaps facilitate providing a copy of his complaint in Spanish. He does require a Spanish-speaking interpreter, and we would like to address bond.
Who is here on the line from the District Attorney's Office?
Judge Troy Moyer, I'm present. I thought I was just going to be present for Eric Brandt's case today. I'm happy to help out where I can. If you could just give me back that case number.
Thank you. It is 20 CR 1715.
Thank you. And if this is not a VRA case, I think we can proceed to send our bond argument if Mr. Stone wants to go first, and I'll try to get caught up on the case.
And Your Honor, Mr. Armando Mendoza's CPAT score is incredibly low. It's actually it's a category 1, but his overall score is actually only a 4, and the only 4 points he has are for not owning a home. He has no criminal history of which I am currently aware. This is his first arrest as far as we know, and I believe that
Hold on, Mr. Stone, you need to stop if you don't mind.
for the interpreter, I apologize.
The interpreter will translate. Mr. Stone, did you wish to say anything else regarding bond?
Yes, Your Honor, just consistent with Mr. Armando Mendoza's lack of criminal history, I do believe there's a good faith basis to suggest that if the allegations in the affidavit those allegations are true, they are one side's perception of a response to Mr. Armando Mendoza actually fleeing an assault from 3 other men, and that he was simply unable to communicate given the language barrier. What was informs me that.
Let me stop you and let that be translated, and then I'll ask Mr.
Understood.
Moyer if he believes it's VRA, because it does have a. Mr. Moyer, it looks like there's a 3rd-degree assault charge.
Yes, Your Honor. I believe this is VRA, so I would be objecting to a bond hearing today.
The district attorney is not in compliance with VRA, is that your understanding?
That's correct, Your Honor.
And Your Honor, I apologize, but if I may, record in this matter, at least is reflected on data access, doesn't actually show that bond that Mr. Armando Mendoza had his bond argued at his first appearance. The record only shows that the protection order was entered and that probable cause was found.
Well, bond was set below guidelines, and the court's belief, after researching this, because this issue has come up a lot, that it still falls under VRA if bond was set. I
just have no reason to believe that Mr. Armando Mendoza was represented when that, or that he had an interpreter, or there's no information about that previous appearance at all, Your Honor.
What I'll do is I'll appoint the public defender to represent Mr. Armando Mendoza. We'll set this for a bond hearing next Wednesday. Actually, we'll do on May 29th for a bond hearing at 1:30, and we'll set it for a preliminary hearing, bond reduction hearing, in 3 weeks. And it'll be R2 at 1:30. June 12th at 1:30 in Division R2. Sir, if you post your bond, you need to come to court on that date. You might see information that the court is closed, but this hearing counts as one of those exceptions to the rule for the court being closed. If you remain in custody, the public defender will be out to... Hold on.
Your Honor, we can't hear the interpreter at all.
Okay. Sir, I am going to appoint the public defender to represent you. I am setting your case for a bond hearing on next Friday, May 29th at 1:30. One of your charges falls under the Victims'
¿El
Rights
29 de
Act.
qué?
May? One of your cases falls under the Victims' Rights Act. And the district attorney is not compliant with that act, so I'm setting it over for a week's time to give them an opportunity to be in touch with the named victims. Whoever's on the line, it's not Mr. Stone, if you could silence your phones, we're getting some feedback. Also, I'm setting your matter for what's called a preliminary hearing or bond reduction hearing on June 12th at 1:30. In the meantime, someone from the Public Defender's Office should be out to speak with you to prepare for the bond argument hearing on May 29th. Do you have any questions about anything I've said?
Pero, entonces, ¿yo voy a estar arrestado o voy a estar libre o cómo va a ser?
You have a bond set at $5,000 cash or surety. If you post that bond, you'll be released from custody, and you'll need to come back to court on June 12th at 1:30 in Division R2. That will be on your bond paperwork. If you remain in custody, you'll be seen on video in a week's time, and the public defender will be visiting with you via video to prepare for a bond argument, where you'll be asking the court to reduce the bond or to release you on a signature bond.
No, yo prefiero venir el 12 y pagar lo que se debe.
Okay, if you do pay the bond and come to court, it's June 12th at 1:30 in Division R2. You will not need to come to court on May 29th. Hearing will be vacated if defendant bond.
El 12 de junio, sí, está mejor porque ya así puedo trabajar y ya. Sí, pues yo trabajo en el roofing.
Okay, thank you.
Sí, amigo. Sí, mejor.
So what? It's going to be a felony plea, so we'll need Judge Blum in a minute. Rick Tosley? 20 CR 1438 and 20 CR 1404.
Yes, Your Honor.
Good afternoon, is it Totley?
It's totally yes.
Totley. And who is appearing for Mr. Totley? Is it you, Mr. Stone?
Yes, Your Honor.
All right, this matter comes on for a hearing on bond. I have 2 cases. The jail indicated 3 cases. Is it your understanding that it's just being heard on 20 CR 1438 and 20 CR 1404 today?
That's my understanding, Your Honor.
Okay, and trying to look at the history of when this was set.
Troy Moyer for the people. Your Honor, I can fill you in on this case. This was my case when it was a district court case. It was 2 felony F4 DUIs. Information was provided from, I think, Larimer County, in which one of the prior DUIs was a successful deferred judgment. So the defendant is not actually eligible for the Class 4 felony. These are misdemeanor DUIs. I filed the motion to amend that charge. This court granted that motion, and Ms. Shannon Carson from the Public Defender's Office added the case on in order to hear bond. In one of the cases, it's set, I believe, at $100,000 by Judge Cox.
I do see that. It looks like he posted bond in 20 CR 1438. Judge Cox revoked his bond and set it at $100,000 cash or surety on April 29th. Is the people in agreement to have this bond set in accordance with the misdemeanor?
So ultimately, yes, my preference, because this is back-to-back DUIs, is on that second case in which there is currently a $1,000 bond, to have bond be doubled for whatever the misdemeanor scheduled amount would be.
And Your Honor, I would just add that Mr. Totally has already posted $7,500 in one case. Well, I apologize. He posted a $7,500 bond in one case, and he posted a $5,000 bond in another case. So he's already posted $1,250 worth of bonds. And so we would request a PR bond or a reduction, a significant reduction.
Okay, so the court needs to determine what the bond would be to see what the people are requesting for a misdemeanor DUI.
Can I ask, Your Honor, is
just
that...
one moment.
Oh, I'm sorry.
It'd be $2,000 for a misdemeanor DUI. The schedule is $1,000, so the people are requesting a $2,000 bond.
And Your Honor, I don't know if I'm looking at the most current bond schedule. The one that I have shows that a DUI with a driving under restraint bond should be set at $10,000. That's just the one I'm looking at. I'm not 100% sure. I have the most recent.
Okay, I do show that, so $10,000 are the guidelines. Mr. Stone, anything else regarding the request for
Yes.
a PR bond or bond reduction?
Absolutely, Your Honor. Mr. Totally lives in North Glen with his son. He rents, but he's been at the same place for 5 years. He's worried about falling behind on his rent payments. He has a cell phone number that is still paid for, so it's valid. He's lived in Colorado almost his entire life. His children, his father, his uncles are all here. He was working full-time operating heavy equipment and for a construction company, and he is confident he can go back. He has gone to AA meetings in the past and plans on attending those again. And then just as to the history, Your Honor, obviously the people are alleging that there are priors. Those are alleged to be from 1990, 1995, and then, of course, there's the successfully completed deferred judgment in 2004. He did also successfully complete misdemeanor probation in 2016, so he's demonstrated a consistent compliance with court orders. I'm as certain as one can really be that Mr. Totally will show up for court if he is able to post his bond, but given that he's already posted so much money, he's running out of money, Your Honor, and I don't think he can post any additional monetary bond.
Thank you. Mr. Moyer?
Thank you, Judge. In the first case, the defendant is accused of hit-and-run DUI, and he posted bond. I think it was 5 days later he got another hit-and-run DUI. I understand that one of these cases was a deferred judgment, but there's at least 2 other instances of driving under the influence, and he violated the bond in the first case by getting another DUI and leaving the scene. So I maintain my request, Your Honor.
Thank you. I believe it was alleged to have been 3 days later. The court will set bond at $7,500 cash or surety with supervised release program and monitored sobriety and the condition of no driving. If he's required to drive for work, he's not permitted to do that. If he needs a valid license to drive any heavy machinery, he's not allowed to do that. And our future dates already set on the cases, I'm trying to remember. There's a disposition hearing scheduled for June 5th at 8:30 in R2, and that's in 1404. Hopefully the other case is on the same date, but I'll see. They are, okay. So June 5th at 8:30 in Division R2 for disposition.
And does this court hear misdemeanors on that day? Since these are all misdemeanor charges, I thought that these cases should just be transferred to a county court, if that's normal course.
That is a normal course, so we need to transfer them to county court. So, I don't know.
My bond, $7,500.
I don't know. Let's just, whoever, let's keep it June 5th, whoever on that day.
May I ask a question, Your Honor?
Okay. Okay. Uh-huh. June 5th, at what time? We can do, 9:30 in Division 3. And sir, what is your question?
The first bond that I paid $5,000 and $7,500, what happened to the $5,000 bond?
That bond was released when Judge Cox granted the motion to revoke your bond.
Okay, so I still have a $7,500 bond, correct?
Correct.
Okay, so I just need to see if my bondsman will get back on the first bond, is that correct?
Correct.
Okay, just see if they'll get back on that one, and then we move forward, correct?
Correct. That's 20 CR 1404 is that case number.
Okay, can I, just a second. Can you say that again?
20 CR 1404.
1404, 20 CR 1404. Okay.
And next court date is going to be June 5th at, 9:30 in Division 3.
June 5th at 9:30 at Division 3. All right, I'll get with my bondsman, see if and that's the lowest we can go on this, even though I've paid so much money already, Your Honor, huh?
It is, given the nature of the circumstances.
Well, just to drive it under restraint.
Mr. Totley, I'm sorry. This is Corey Stone. I'm from the Public Defender's Office.
Okay.
I'm going to ask you to stop for now, okay?
Yep. Yes.
We'll talk to you soon, though, okay?
Thank you, bye.
Thank you.
Thank you.
All right, we are going to need Judge Flom to come for Mr. Golat's matter. I understand that's a felony plea, is that correct?
Brian McGarry for the people.
I don't believe that's correct, Your Honor. We were requesting to waive preliminary hearing and set this matter for arraignment.
Oh, I'm sorry. I thought I saw plea paperwork. Plea paperwork was filed on April 30th?
For Raphael Golat?
Yes. But perhaps he's changed his mind.
Yeah, they tried to hit me with a weapon. I remember that, yeah. Trying to say I hit it like a firearm.
Oh, is this the one that, Mr. Golat was going to enter a plea but, changed his mind? Let's call this case and find out, because we might not need Judge Flom. 19 CR 5029, Raphael Golat. Good afternoon, sir.
Good on.
And Your Honor, I apologize, but I think that plea agreement was filed by Mr. Golat himself rather than his attorney. So we would request to waive preliminary hearing today and set this matter for arraignment and also address bond.
All right. Mr. Golat, is that what you'd like to do?
Yes, ma'am.
Can you tell Judge Flom to hold up? Thanks. All right. I'll note a waiver of the right to a preliminary hearing, and we'll set this matter for arraignment. With respect to bond, Mr. Moyer, do the people have any objection?
And this is Brian McGarry for the people. We are VRA compliant to address bond today.
Okay, Mr. McGarry. Mr. Stone, what would you like to say regarding bond?
And, Your Honor, while Mr. Golat's bond was previously reduced to $2,500 cash or surety, that was the previous PH setting, which was 3 weeks ago. And obviously, he's been unable to post an amount that high. He's hopeful for a reduction because he has word that there are 2 different jobs that are available to him. And if he stays in custody, he'll lose those opportunities. His mental health has also been suffering while he's been in jail. He's been, well, he was initially in isolation and in the mental health unit, and he's experiencing a lot of anxiety and depression right now, Your Honor.
Okay, Mr. McGarry, what's the people's position?
And the people and the victim both object to further modification of the bond. The victim previously objected to a modification of bond on April 30th, and at that time the bond was cut in half from schedule. And the severity of the allegations in this case and the victim's safety concerns are also concerns for the people, so we would object to any further modification.
The court's going to leave the bond as set at schedule. It's $5,000. It's, I'm sorry, $2,500. It's well below guidelines. It's already been reduced. I've reviewed the affidavit and the pretrial report. So bond will remain set, and we'll set this matter for arraignment. Are there any preferences to days?
A Monday or Wednesday, please, Your Honor.
Wednesday or Thursday, please.
You said Tuesday or Thursday, Mr. McGarry?
Wednesday or Thursday, please.
Wednesday. So let's find a Wednesday in... June 17th, does that work?
That works, Your Honor. Thank you very much.
Okay, what time?
That works, thank you.
8:30 in Division L. So June 17th, sir, at 8:30 in Division L for arraignment.
I have court in Westminster on June 17th.
Okay. Do you know what time?
No, ma'am. I don't know exactly what time.
Okay, we'll try to find a different date. 24th? At what time? 8:30? Does that work for the parties?
Yes, Your Honor.
That works.
Okay.
Thank you for accommodating that.
Your Honor, I got one more question. Are you able to tell me how many bonds I have right now?
I can't tell you that. I only have this case in front of me, sir. Jill can let you know that information, okay?
Okay. All right, thank you.
Thank you. All right, we have, a senior judge is going to call in for Mr. Brandt. Is the jail going to bring him in?
Actually, Mr. Brandt was a refusal.
Your Honor, Matt Telland, attorney for Mr. Brandt, if I can address that issue.
Well, the court is recused from hearing that, so we'll need to have the senior judge call in. Do you know if he's going to give any information?
Your Honor, what I can let the court know, Mr. Brandt is in the Jefferson County Jail. He is in a position where the court can call and add him to this phone call, and we can address everything that way. But he is not in a position where he can make a phone call out from the booth that he's in.
He's in the Jefferson County Jail?
He's in the Adams
That is
County
correct,
Jail.
Judge. He is not in the Adams County Jail. He is in the Jefferson County Jail. He has been in the Jefferson County Jail for months.
Oh, yes? Oh, yeah, yes.
Okay, so I guess, do you have a number for Jeffco?
Yes, I do, Judge. I can. I believe that has been sent to your clerks, but I can give that to you now if you're ready.
Well, the clerk that was for Division R2 is out today, so we have a different clerk. So if you could please provide that.
Sure. The number to reach Mr. Brandt at is 303-271-5666. 5113.
Okay. And we'll do that case when the senior judge calls in, I guess. In the meantime, who does the jail have in Adams County custody that they are bringing in or has been brought in? Does the jail anticipate bringing down Mr. Younger? Oh, he's not here. And
Your Honor, the last two that we have is, Ms. Iriba and Mr. Duran.
okay.
They're isolation, so as soon as, our hallway's open, they're closed at the moment, we'll get those in.
Okay. Well, I'm going to mute the jail. If you could mute on your end and then just give me a wave when those people are brought in. I'm going to do some other matters that are not in custody.
Your Honor, Lucas Worth here. I'm an attorney for Mr. Christopher Forbes. It was appearance on arrest warrant. He's in Jefferson County Jail. I sent him a writ. It was my understanding that he wasn't going to be able to make it over there for this appearance.
All right, I'll call that case. You ready, Steve? Christopher Forbes.
See it goes off.
Okay, that's 19 CR 4685. And counsel, please enter your appearance again.
Lucas Worth, W-I-R-T-H, bar registration number 37324, representing Mr. Forbes, who is in custody at Jefferson County. About a month and a half ago, I entered my appearance, filed a writ of transport. It was granted, but I talked to Mr. Forbes, and he told me Jefferson County wasn't transferring anyone.
All right, for the people?
Brian McGarry for the people. He's in Jefferson County?
Correct, being held on like at least 5 cases.
Okay. So there's an entry on this. Go ahead.
Sorry, I was just going to say we can reset the matter, and I don't know when Jefferson County plans to start transporting people again, or we could do a video writ.
That works.
All right. Court has not done a video writ, but it sounds like you all have. I'll authorize the video writ to issue. I cannot issue that writ. The district court judge will have to issue it, and we'll reschedule it. Are those done via WebEx?
They are. Does your courtroom have that technology?
We're working on it. And we hope to have it up and running in June, so we're thinking about Thursday or Friday mornings around 10:30. So
June 4th?
June 4th? That may be a little early because Ms. Gasser doesn't return till the 27th, and we're still...
I could do the 25th.
June 25th?
Yes.
At 10:30 for WebEx
Yes.
appearance. And if you all could educate me, what does the clerk need to do on the clerk's end?
We
you
will
already
file,
received instructions and you have, go ahead.
So we'll file something on our end. We'll just have to have everyone's email address that on email. I don't know if I've ever done it with Jefferson County. So I'm trying to think if everyone is using WebEx by now in other jurisdictions.
I know Denver is.
I'm wondering if we can have him call in.
Does anyone know if Jefferson County will be transporting in June?
No idea.
I haven't been given an update on when they're starting again.
Deputies, do you know if Jefferson County will be transporting defendants in June?
I honestly don't know.
Okay.
That'd be a question for transport, I think.
Yeah, I did overhear transport. They're gonna have a meeting with the sheriffs, I think, to kind of get that whole transport thing squared away between us all counties. So hopefully we'll know something soon.
Okay. Well,
I'm okay with setting it on the 25th of June to try and actually get him writted here physically. But if we learn more information along the way that that's just not going to be possible, we can file something with the court asking to do something else.
I agree. That gives us ample time to be able to come up with a plan B and C if A doesn't work.
okay. So if we do it at 10:30, and he's not writted and WebEx doesn't work, we'll call the case and we'll figure out where to go from there.
Perfect.
Yeah, and just notify the court if you are able to work something out, if you need us to change the time or anything like that.
Will do, Your Honor.
Okay, matter continued to that day. Dawson French. Actually, before I call that case, are there any more, is Mr. Duran a transfer hearing?
That's correct, Your Honor. Corey Stone for Mr. Duran. We would just request for this matter to be set along with the escape charge itself, which is currently set for June 23rd.
Any objection from the people?
Brian McGarry for the people, no objection.
18 CR 629 is the case number. And do you have the other case number?
Yes, Your Honor, that's 19 CR 2367. And Mr. Duran did have an additional request. He would just ask that the court order him held at Adams County until his next court date. He's afraid that they're going to take him back to Larimer and then he won't make his way back here and that he'll fail to appear, and he very much doesn't want to do that.
Okay. Mr. Duran has still not been brought down. I was just trying to find out if we are going to need Judge Flom, so we'll do this on the record, but appreciate that information, and the court's willing to make that order.
Thank you, Your Honor.
We don't need Judge Flom. I don't think we'll need him.
I don't believe we have any pleas this afternoon, Your Honor.
Okay.
Not from the public defender's office. I don't know. I do see that there's one additional private counsel matter.
I don't know if I called. Who do you have? The jail is bringing in some folks. Who do you have?
Your Honor, so we have Renee Iriba and Randy Duran.
Okay, we were just talking about Mr. Duran's matter. 18 CR 629. Good afternoon, Mr. Duran. Come on up to the podium, sir.
Good afternoon.
Good afternoon, sir. I'm Magistrate Wheeler, and on the phone is Public Defender Corey Stone and a representative from the District Attorney's Office. Mr. Stone?
And Corey Stone for Mr. Duran. Your Honor, Mr. Duran's, he's set for a community corrections transfer hearing today. We would request that the hearing be set for June 23rd. That is the same date as the escape charge case itself, 19 CR 2367. And we would also request an order that Mr. Duran be held at the Adams County Jail until that date so that he does not fail to appear. And that request was Mr. Duran's request, just for the record.
Any objection from the people?
Brian McGarry for the people, no objection.
All right, Mr. Duran, I will order that you be held in Adams County. I will also continue your matter to June 23rd at 9:30 in Division 3. The same date as 19 CR 2367. Your transfer hearing will be continued to that date, and I will order that you be held in Adams County until that day.
Thank you, Your Honor.
Okay, thank you. Did you get all that, or do you need anything else? Okay. Renee Arabia. 20 CR.
Good afternoon, Your Honor.
Good afternoon. This is 20 CR 1212. Ms. Arabia is in custody. and this is for a setting of a preliminary hearing. Mr. Stone, did you have a chance to speak with Ms. Arabia this morning?
I did, Your Honor. Corey Stone for Mr. Arabia. She's been advised of the charges and of the complaint. We would waive any further reasoning of the advisement and ask for the public defender to be appointed. There is we would like to address bond, Your Honor. There has been a change in her circumstances since the 20th. I know that her bond was just addressed on the 20th, but her bonds in her other cases all just changed to PR bonds as of today. Given that given that change in circumstances, we would like to address bond.
Any objection from the people?
If I could just have 1 second.
Mm-hmm.
We can address bond today.
Okay. Mr. Stone, go ahead.
And Your Honor, Ms. Arabia is, she's mainly concerned about her 5-year-old daughter. Her name is Anna Zay. She is currently with her grandmother, but her grandmother is getting older. She is self-employed her grandmother is self-employed as a house cleaner. So, and that's her family in the area. So, there's only so long that she'll be able to take care of Ms. Arabia's daughter on her own. Ms. Arabia was hopeful that she would, if released, she would also begin to take an increasingly larger role in that house cleaning business as her grandma gets older. And then finally, Your Honor, her other cases were 2 Denver cases. One of those was recently refiled as a misdemeanor in the other Denver case. While it is an F4 felony, the bond in that matter was just today changed to a personal recognizance bond.
Is there any supervision by Denver on that bond?
That is a good question, Your Honor, and I apologize. I am not certain. But I can look that up.
What is the charge?
The charge, I believe, is burglary, Your Honor.
What's the people's position?
And I'm looking at the defendant's pretrial services report, which indicates she is a CPAT risk category 4 and has a criminal history that is full of FTAs and FOJs. And so at this time, I think the scheduled bond is appropriate, and I would object to a personal recognizance bond.
And she is under enhanced pretrial supervision in Denver, Your Honor.
Mr. Arabia, I'm going to authorize the PR bond over the objection of the district attorney, and the reason why I'm doing that is I'm hopeful that your concern for your daughter's well-being and ability to care for her is going to incentivize you to come to court, okay?
Yes, ma'am.
I don't normally give PR bonds, but also we have a coronavirus pandemic, and I'm going to make that condition upon supervised release program. I'm not going to require, supervised release program is authorized to make sure you're in compliance with your Denver bond. I'm not going to put any monitoring conditions on that, but you will need to check in with them, call in and check in with them as a condition of your bond, and you should do that immediately upon your release, as well as apply for the public defender. Do you understand?
Thank you, Your Honor. I do understand.
Okay. And the amount of the PR bond will be $2,500 with the supervised release program, and we'll set this for a disposition hearing.
Okay.
And do you know when your next court date is in Denver, Mr. Stone?
I believe one of them is in 2 months, but the other one just got PR today. So if you can give me those dates, I would greatly appreciate that, Your Honor. I think the other one's a Wednesday in 2 months, I believe. One of them for 3rd-degree assault.
Okay. May 29th, we're going to go into July, so let's see.
And actually, Your Honor, because that PR bond was just authorized today, I think Ms. Arabia will be able to post it at the jail and then receive her new court date, but I don't think there is a new court date set in that matter just yet.
Okay.
Okay.
Well, any court dates would be great.
Let's look at like
All of them.
July 24th.
Okay. July 24th?
I'm just talking to the clerk. I'll find out if that's...
Okay.
July 24th, what time in the afternoon? At 2 p.m. in Division R2.
R2, Division R2?
Yes, ma'am. And
Thank you.
you'll also want to apply for the public defender, see if you qualify, and do that as soon as possible. You can do that online, or you can call their office for directions if you don't have internet access, okay?
Okay.
But don't forget to check in with SRP immediately, follow through with all of their instructions, otherwise they're gonna send me a report, and they may be asking I issue a warrant for your arrest. I expect strict compliance with them, given the opportunity I'm giving you, okay?
Thank you, Your Honor. And they'll give me that when I'm released as well, right? They'll give me all the information to check in and stuff like that?
Yes, they'll meet with you
Okay.
and give you all that information upon your release.
I appreciate the opportunity you're giving me. Thank you very much.
You're welcome, Ms. Mejia. Take care.
Take care.
Wonder if we want to email Lynette. Is a senior judge on the line?
I'm sorry?
Is there a senior judge on the line?
No.
For Mr. Brandt, we're supposed to have a senior judge calling in. Who's the jail have? Anybody left?
Nope, that is it.
Okay. Okay. The parties, okay with me signing off with the jail?
Yep.
Okay. Younger is not here.
And I'm sorry, Your Honor, what did the jail say about Mr. Younger?
They said he's not here. He was not back from his writ, so I'll call that case 20 CR 1460.
And Corey Stone for Mr. Younger. The court has just informed Mr. Younger's counsel that he was not transported back on his writ. We would just request to set this matter for a preliminary hearing fairly quickly, Your Honor.
Okay. So, June 12th? Does that work?
I apologize, Your Honor. I got some guidance from a supervisor in his case specifically, and I'm just taking a look at it. And June 12th will work, Your Honor.
All right. Mr. Younger's case will be continued to June 12th at 1:30. People are to writ, or he's coming back from a writ, so I guess Adams is his home jurisdiction.
Yes, Your Honor.
Okay. And can you message Lynette that we have the means to call Mr. Brandt, but the senior judge hasn't called in? I think it's just... The colony? He will call us. We have to call him when we call him information. Okay. So we have Mr. Brandt, and then we have an out-of-custody matter, Ms. Smith.
May I make a brief record, Your Honor? I apologize for interrupting. On French, 18 CR 4774.
Uh-huh.
And, Your Honor, our report from the jail was that was that they refused, but they didn't. He couldn't be transported due to the outbreak that's continuing in Sterling. So we would ask to set this over and just let the record reflect that this was not, in fact, a refusal.
Okay, the record will so reflect. The clerk is on the phone. Give me just one moment. It's not WebEx. Yeah, this is phone. We're not using WebEx right now. No, you can call in, like, the attorneys have called in. By phone, he'll call in the. Because we have to call them. Okay, and that number is 303-651-3365. Yes, now, and then one more call if you're over the other number. To call me. It's 53715. Okay? Yes. Please go ahead and call it. Okay, please hang up and then you get that call. Wonderful. Thank you so much. Bye-bye. All right, and the court will make a note that on Dawson French's case that he didn't actually refuse transport, that because of the coronavirus outbreak at Sterling, he's not allowed to be transported. 18 CR 4774, this matter will be reset for preliminary hearing. Do we want to go out 6 weeks?
Yes, please, Your Honor. I think that makes sense. It's unfortunate that it's outside of 35 days, but I think given the situation, that makes sense.
Okay, the court will find good cause to continue it beyond the 35 days due to the pandemic and the fact that the pandemic is rampant in the Sterling Correctional Facility where Mr. French is housed, so continue to July 2nd at 2 p.m. for a preliminary hearing.
Thank you, Your Honor.
Thank you. And before the court leaves the bench to allow is the senior judge on the line?
I am, yes.
Okay, good afternoon, I'm Magistrate Wheeler. I'm going to call one out-of-custody matter, and then we have counsel for Mr. Brandt is on the line. Mr. Kelland, are you still there, Mr. Kelland?
Yes, I am.
Okay, thank you for your patience. The senior judge has called in, and we have a phone number to contact Mr. Brandt, who is currently in Jefferson County Detention Center. I'm going to call the final case that I have, which is Destiny Smith, 20 CR 1459. Ms. Smith, come on up to the podium. Good afternoon, ma'am. If you could avoid touching the podium, that would be appreciated. Ms. Smith, you are here on bond. Your matter is scheduled for a preliminary hearing. The court appointed alternate defense counsel to represent you. Because you're on bond, you will need to reapply, but if you qualify, the alternate defense counsel will be appointed to represent you. Do you know how to apply for the public defender?
No.
Okay, do you have internet access? Okay, there's also an application in the podium. You could take that application, but you can go on their website and complete an application online. That's the quickest way to do it. And Your matter is set for a preliminary hearing. However, you don't have counsel. You are no longer entitled to a preliminary hearing on bond on this case. Who's appearing from the district attorney's office?
Brian McGarry for the people.
Ms. McGarry, is it correct that this is not a preliminary hearing eligible charge?
Correct.
Okay. So, ma'am, we'll set your matter for a disposition hearing. We're probably going to go into July.
Okay.
Let's look at the July 20th week. And 22nd in the afternoon, or 23rd or 24th. Okay, July 22nd at 2 p.m. in Division R2 for preliminary hearing. For disposition, thank you.
What time did you say?
2 p.m. R2 is going to be the courtroom next door.
Okay.
And once you apply for the public defender and qualify, Mr. Cordero will be appointed to represent you. Do you have his contact information?
I don't.
Okay. I believe he'll be notified once the public defender's appointment is, we see that there's a conflict. I don't know if we have any information we can give her on Mr. Cordero, but, or if he has her information. Okay, we'll give him your information.
Okay.
And if it should change, call the court and let us know, okay?
Awesome.
And your bond will continue. Is there any supervision on your bond? I'm trying to see. No other conditions other than to come to court and abide by the other standard terms and conditions. So your bond will continue to that date, meaning it is mandatory. Any questions?
Nope.
Okay, thank you for being here.
Thank you.
I do have a 3 o'clock matter. I stupidly scheduled. Whipple-Rich. That is Cameron Vogt. Is anybody on that case? 19 CR 174. Appearance on arrest warrant writ.
Brian McGarry for the people.
I don't know why he would, it looks like he was sentenced on May 10th. That's 2019. Appearance on arrest warrant. A writ was granted on March 23rd. Oh, Mr. Vogt was at the window. He had court today at 2. He went upstairs, but the courtroom was locked. We gave him the phone number to contact the division clerk. Telling him to come to courtroom 204. Should have been a sign on the 203 saying to come to 204. Mr. McGarry, we're just communicating with court judicial assistants. Apparently, they told him to contact the division clerk, but they're going to see if they can catch him. If not, what I'll do is I'll continue this to next week. But since I have to do a 3 o'clock with Rich, with private counsel, and Mr. McGarry, do you know, are you on Whipperich?
Yes, I am.
Okay, so that's scheduled at 3 for the attorney and the defendant to call in. Going to see if they were able to catch him. We're going to continue Mr. Vogel's matter, noting that he was here. Courtroom 203 is locked. We were having court in 204. There wasn't a sign on the door. This is 19 CR 174. We'll continue to Kelsey's not back till the 27th. I don't know if he'll get a notice of hearing or... Well, let's continue to the 29th. We'll continue to May 29th at 2 for appearance on, well, bond. Looks like he bonded. And that
Okay,
concludes...
thank you.
Thank you.
Thank you, Your Honor.
Try to contact Jeffco. I don't know. Okay. Yeah. So, I guess we can put her on speaker and put the microphone.
Is this it? Oh, this is Brandt? Okay, wonderful. Hi, I'm calling with, R2, and I've got everybody by phone, so can you just hang on for just a second? Thank you. Can you still hear me?
I can hear you.
Okay, can everybody hear? Judge?
Yes.
Gary?
Holly Wilkinson and Tori Moyer for the prosecution. We can hear.
Okay.
Matt Kelland for Mr. Brandt. I can hear as well.
And this is Mr. Brandt appearing by phone from Jefferson County Jail, and I can barely hear the other attorneys, but I'll get with my lawyer if there's something that I missed that I didn't understand.
Yeah, and Mr. Brandt, it's you're a little quiet as well, so if there's anything you need to say, please make sure you speak up.
Yes, sir.
So, are you ready to call this up?
Yes, we can go ahead and call it up.
So, I'm sorry, would you give me your name again, the clerk? Because I've been given like 4 names over the last 5 days.
And I'm not a regular here either, Judge. My name is Deb Adkins. I'm normally in Division 6 with Judge Flom.
Okay. Well, I'm still not sure I caught your name, but if something needs to be drafted up from this or, you know, you put in my inbox or whatever, I need to know who's going to do it. So
yes.
we can talk when we're finished here.
Absolutely.
All right. And do you have Ms. Easton on the phone from the Jefferson County DA's office?
No, Your Honor. Holly Wilkinson and Troy Moyer from the Adams County District Attorney's Office.
All right. So I'm calling up 2 cases today. We'll call up the new case first, 20 CR 19, People versus Eric Brandt. This is Judge Shapansky, senior judge, and again, we're all doing this by phone as I understand it, just so the record's clear. No one's appearing personally in the court. I was appointed on this new case mainly because I have an older case with a motion to revoke that is out there and is filed just in the last couple of months, and I'll get to that in a minute. But Mr. Brandt, first of all, on this new case, you have 4 charges that have been filed against you. Retaliation against a witness or victim, that's a Class 3 felony. Retaliation against a judge, that is a Class 4 felony. Another count of retaliation against a judge, a Class 4 felony. And intimidation of a witness or a judge, also a Class 4 felony. your bond was set in this case at $20,000. You failed to appear. It may have been that you were in jail. We'll get to that in a minute because I see a consent of surety was filed in this case. That bond was revoked. Actually, judgment was entered on it, and your bond was increased to $50,000. You have counsel, Mr. Kelland, who's entered an appearance in this case. So let's stop right there. Mr. Brandt, do you have any questions about any of that?
No, Your Honor, I don't, and for the record, I do consent to conducting this hearing by telephone if the record needs that.
Okay, thank you. So let me ask the people, first of all. The reason I brought up the Jefferson County is that Ms. Easton was appointed as a special prosecutor in this older case. Is your office going to prosecute this?
Your Honor, at this time, there has been no request for a special prosecution either by the prosecution or the defense. So currently, the 20 CR 19 case is being prosecuted by the Adams County District Attorney's Office. I understand there is a probation revocation that originated from Adams County and that a special prosecutor from Jefferson County had been appointed, but that is not the procedure on the new case at this time.
Okay, and we'll get back to that other case in just a minute. So, Mr. Brandt, you have a right to a preliminary hearing on this case. I don't know if you and your attorney have discussed that, whether you want to ask for that, whether we need to get into the question of whether it will be heard in 35 days or that is being waived. So, Mr. Kelland, what's the situation on that?
Well, actually, I guess that's one of the things that we didn't talk about. Eric, are you comfortable waiving the preliminary hearing on this case?
I thought that we were going to continue this matter out, and we haven't discussed that matter.
Okay. Your Honor, if possible, we would ask to continue this case, and we would not be requesting a preliminary hearing today, but we would also request that we not be required to waive a preliminary hearing. I can let the court know that I have been in contact with the district attorneys present on the phone call and the district attorney in the Jefferson County case. We are trying to put together some sort of a global disposition involving Adams County, Jefferson County, Denver, and it sounds like there may be a recently filed case in Arapahoe as well that we might have to rope into that. So at this point, Judge, we are trying to resolve these cases, and we'd like to continue exploring that route without either requesting or waiving a preliminary hearing.
All right, Mr. Brandt, you understand you have a right to have a preliminary hearing on this matter?
Your Honor, I do.
Okay. And according to your attorney, you're not waiving your right to have it, but you are waiving your right to have it within 35 days. In other words, you're preserving your right to have it, and we can address that at a later time. Is that understood?
Yeah, well, my understanding, just for the record, was that we were going to not start timers today because we wanted to not invoke trigger a bunch of expensive procedures when there's a reasonably good likelihood that we can resolve these issues. So it was my understanding that we were going to ask to continue the advisement and arraignment out, and that I was not going to start any timers today. That's what I understood. So if I'm wrong on that, then I guess I would need to speak to
Mr. Killen can address that in a minute, but I think we're kind of talking about the same thing, but not exactly. So just so we're clear, we're not putting your advisement out today. At least that's not what my intent is. And at the same time, the clock is not running, the clock is not running on your preliminary hearing because you preserved the right to ask for that preliminary hearing. So is that understood?
I think so.
Mr. Kelland, any input on that?
No, the only thing I wanted to say with that is, Eric, I think going this way is exactly what we had been discussing and trying to do. So my suggestion is that we preserve the right but not request to have a preliminary hearing at this point.
Okay.
All right. So what we're going to do in this case, and I'm going to get to this other case in a second as I understand it, we're going to set this out for possible disposition, further proceedings at some timetable we all agree on. Is that right from the people's standpoint as well?
Your Honor, I have no objection to setting this out. I agree with the court procedurally. I would prefer that we set it for a preliminary hearing, and then we can address that later down the road, understanding it would not occur within 35 days. But I would rather do that procedurally than keep it in county court, as it were, for procedural purposes.
Well, again, different districts do this differently, but as far as I'm concerned, you know, I'm a retired district court judge. This is not in county court, even though that may be procedurally how you would do things in your court, but other counties do it a different way. Bottom line is, I have jurisdiction to hear his preliminary hearing. I understand what you're saying, and it doesn't make a lot of sense to kick a preliminary hearing out, you know, for 8 or 9 months if things don't work out here. At the same time, I don't know that it makes sense to prepare for a preliminary hearing because we might have to have it on that date if we don't reach a disposition. But what I want to emphasize there, Mr. Kellen, and you can discuss that with Mr. Brandt, is by the time we appear next, if you don't have a disposition, we're either going to set a preliminary hearing or you're going to waive that.
Judge, I think we can make that happen. I think that's fine.
And I think I understand that, and I guess what I also interpret from the people's conversation is that the court is going to go ahead and bind this up at this time. Is that correct? Without the preliminary hearing, I have no objection to that.
Binding up might not be exactly the word for it because we're not, again, having a preliminary hearing today and deciding whether there's probable cause. Again, you can be advised in the county court, you can be advised in the district court. As I said, different districts handle this differently. The district I've practiced in forever as a judge and attorney, everything went right to the district court. So the bottom line is there's no binding that's necessary or a finding on that. These are felonies, they're district court matters, and we're going to set it over to see if we can get this resolved. If not, we're going to set a preliminary hearing at that time unless you care to waive it. Okay?
It appears to me that I understand what the process is here and that it is in line with what my attorney had discussed with me earlier. So thank you for clarifying that for me. I appreciate your time.
Okay. So, but before we set that, let's talk a little bit about this other case just to make sure what's going on there. Now, Mr. Kellen, the public defender has moved to withdraw in that case. Are you familiar with that case? Are you alternative defense counsel? Is that correct?
Yes, Judge, I am alternate defense counsel. I knew that case was out there. I'm passingly familiar with it from my discussions with Mr. Brandt and also some of the
well, let me just, I'll summarize it for you real quickly, okay? On April 19th of 2018, this is case number 17-CR-1584, People versus Eric Brandt. Mr. Brandt pled guilty and entered into a deferred sentence agreement. The court approved that and ordered it on 3 counts. Attempt to influence a public official, that really was the only count that was subject to the deferred sentence. The others, one had a suspended jail sentence and the other had a fine, and the people have not moved to impose a suspended jail sentence at this time. They've only moved to revoke the deferred sentence on count 1, the attempt to influence a public official. That's a class 4 felony. In summary, there's a long affidavit that goes with this, and the allegation is that he has violated this by committing another criminal offense. That affidavit lists 12 separate criminal cases filed against the defendant after April 19th of 2018. If the affidavit was correct, this back in April, all those but one were still pending and set for various things. One of them, according to the affidavit, he had already pled guilty to, and that was violation of a protection order in Adams County case number 19M427. Obviously, Mr. Kelly, you can discuss this with Mr. Brandt, but the people don't need to prove 12 of these. They only need to prove 1. At the same time, I assume since you're talking about a global disposition, that you want this put off as well to see if you can reach an agreement on it. Is that correct?
That is correct, Judge. And my understanding is that the deferred case, the 17-CR-1584, is still subject to the special prosecutor Ms. Easton, I can see that she filed the motion and submitted the affidavit, and I know that she's not on this call today, so I don't want to do too much with that case. What I would ask, however, I would ask that the court grant the public defender's motion to withdraw so that I can file my entry, and I would also request that this case just be set over to whichever day we set the 20 CR 19 case for.
I will grant the public defender's motion to withdraw, and I'll do that electronically in my inbox, and I will appoint you as alternative defense counsel. Yeah, as far as I know, Ms. Easton is involved in that, and as I said, I communicate with 3 or 4 clerks or supervisors of court reporters and so forth about today's proceedings. Somebody told me they advised Ms. Easton of this, but obviously that didn't happen or she didn't get contacted. So the only downside to that is, I mean, this is going to trail along with that other case. Now, Mr. Brandt, just so you're clear, I set bond in that old case at $5,000 personal recognizance. I mean, the reason I set it at personal recognizance, despite the fact that you got all these things going on, is one, we got this COVID-19 thing going on, but secondly, again, this case is dependent upon you being found guilty or having pled guilty in some other cases. So in order to kind of not pile these on top of one another, that has a personal recognizance bond. You may not be getting out of jail for any number of other cases you have, but the bottom line is you could on this case by signing the bond. Do you understand that?
Yes, Your Honor, I do, and I haven't signed that bond yet because I don't want to lose what time I might be earning and any potential penalty that the court might impose if we get to that road. But in the event that we're able to address other bond questions, which I think that my attorney's going to get to, then I will most humbly and graciously accept your PR bond and sign it at that time.
Right. I'm not trying to push you into doing it. I just want to make sure you understand the status of it, and it sounds like you do.
Thank you, Your Honor, I do.
Okay.
And I appreciate that. Thank you.
All right. So we'll get to the bond in a minute, but my point is when we set this over, it will be both cases. There's a possibility Ms. Easton could have some conflict, but maybe she could get someone else to cover it, or we could move it if we have to, but we are going to go ahead and set some date today. Let's get to the bond.
That. I was actually hoping that the court would be able to address that case today as well, so I appreciate the court's jumping out the gun on that. That's awesome. Okay.
So in the other case, we had a consent of surety filed, and do I understand it, Mr. Kellen, that the argument here is that Mr. Brandt was in jail and could not appear? Is that what it is?
That's correct, Judge. Mr. Brandt was arrested by Jefferson County sheriffs and has been in the Jefferson County jail since, I believe, January 28th of this year. So that was prior to any of the dates in this case. And at that time, Jefferson County was not honoring any writs. So our position is that the FTA was unavoidable and something that Mr. Brandt had no control over. He does have a very good relationship with his bondswoman. He has expressed to me on a number of occasions his concern for always making sure that he takes care of her and honors his commitments there. Well, I think her husband might have been the one that filed this case, but either way, Your Honor, they have filed, they've sent over a consent, which I filed today, and we would request that the court reinstate that original bond now that we have a consent filed.
Do the people have any argument on that?
Holly Wilkinson on behalf of the prosecution. Your Honor, the issue that we run into is one of VRA. What I can tell the court is we did not get notice regarding the consent until it was filed with the court, and that occurred this morning. We have 3 named victims, all under the VRA, in 20 CR 19. We reached out by email to all 3 of those victims, and we only received 1 response back, which was an objection. However, Judge Crespin has not responded, as did the Deputy Sheriff Bonder. So we are not in VRA compliance to be able to address this at this time. I understand the legal argument, but we just didn't have sufficient notice to be able to make VRA compliant.
Well, let me ask you this, and I mean, obviously the judge, and it wasn't me, who revoked the bond. Now judgment's been entered on that bond. It seems that it was noted even then that he was in jail somewhere else. Do you dispute that?
Your Honor, it does appear as though there was information that he may be in custody in Jefferson County or potentially somewhere else because there were multiple cases pending. Specifically Denver, I think, was already pending at that time. However, because the bond's been forfeited, the bond doesn't exist, and quite frankly, this would be the court accepting the consent, reinstating the bond would be a change to the bond because the victims were all notified that bond was set at $50,000 cash or surety.
Well, that is true.
Can I fill in some blanks on that, Your Honor?
Well, Mr. Kellen, did you want your client speaking or not?
Your Honor, I think that Mr. Brandt has a substantially better than the average defendant has an understanding of what things are acceptable and what things aren't acceptable to say. So if he wants to briefly address the court and provide some more information.
Well, I'm not talking so much about what's acceptable to say. Mr. Brandt's always been very courteous and appropriate with me, but what I'm talking about is the people's statement, which is, I mean, the Victims' Rights Act obviously at times, runs head on into sometimes common sense. In other words, I mean, obviously that act is important. There's a reason victims need to be heard from. On the other hand, some things are just kind of obvious from the record. But I do think the prosecution's correct. I obviously can vacate the judgment on that other bond and reinstate it, but that bond's not in effect right now. So I think that's more of a legal argument than probably what Mr. Brandt is intending to address here.
Your Honor, it might be.
If I may then, to fill in some blanks, because Mr. Kellen was only recently appointed and I have kind of survived the ordeal. I actually when I was arrested on January 28th, my supporters and my bondswoman, are you still there?
I'm still here.
Yeah.
My bondswoman provided consent to my supporters, and we tried to address this issue back in February. So the people have certainly known that I'm in Jefferson County the whole time. I have spent 5 months trying to get over to Jefferson County or to Adams County to take care of this issue. We've had consent ready each time we've done that. We've had to go through hoops to get the public defender appointed and then withdrawn to get Mr. Kelland appointed. The consent has been there the whole time, certainly forever. The people have known that I've been trying to take care of this bond. Every time Adams County has come to try and writ me for this, another jurisdiction has snagged me before you got to me, and I haven't been able to get over there. But I have made earnest attempts to get over to that court to try and handle this bond over the last 5 months. And if the court isn't able to address bond, well, first of all, I think it's sort of disingenuous for them to think that all of a sudden we want this bond question, when that was really the question at hand today. It was certainly the number one question that I asked my lawyer to make sure that we address, and we've been working on this for several weeks. And I have other judges that are waiting for this judge's decision on this bond question to address other bonds. I have underlying health conditions. We have a serious outbreak of COVID here. But even with COVID notwithstanding, I have made every attempt possible to take care of this bond for 5.5 months. And if the court can't address the bond itself today, then I would ask you to please release my bondswoman and vacate the judgment against her, because that woman doesn't deserve any of that. And we have made our efforts. So I would ask the court to please consider
that wasn't my dog, although I have a dog. Okay. So in any event, from the people's standpoint, do you need I assume otherwise we're going to put this off for a couple of months on both of these proceedings to get through, again, some of the concerns of the court for safety and so forth, and chief judge's orders and what have you. Is that correct from the people's standpoint?
Yes, Your Honor. What the prosecution would be recommending is that we set this over for a reviewer status on the bond issue for VRA compliance. I understand the defendant's argument. I understand the legal issues that exist. Notwithstanding VRA, we would be having a different conversation.
But you may misunderstand my question. As far as this global disposition and so forth, you are talking about putting this off till July or something. Is that correct?
I believe it will take that much time just to get all 4 jurisdictions to be able to present a global disposition for all cases. Right. Yes.
So I don't want to put off this question of his bond for that period of time. So I see one of 2 possibilities. One is, I suppose we could try and get everybody on the phone again in a week or something. The other is that I could give you some period of time for you or these victims or witnesses to respond in writing to this.
I do believe, given the number of parties involved, Your Honor, it may be more effective to file a position in writing, and the court can then rule in writing.
Okay. And so how long do you need for them to do that?
That is a little tricky, Your Honor. We had an incident occurring at the courthouse in which my victim judge is currently under quarantine. So with that being said, if I could have until the end of next week, so May 29th, I think that should be sufficient. If the court is asking to set it sooner than that, I will do my best.
No, I don't think that's unreasonable. And again, Mr. Brandt, Mr. Kellen, I mean, I've got to comply with the Victims' Rights Act, and so I mean, this is again a legal question. I think they're entitled to respond to. So I will give any of the victims.
Can I just want to make sure my objection is heard. I've literally been trying to handle this for months, and for some reason these keep getting put out and put out and put out. So here I am, totally releasable and bondable, and yet every judge keeps putting this out and putting this out and putting this out. One of her victims works down this hall from where you're at right now, and all of these victims have electronic communication is highly available. I think that the Victims' Rights Act is an important act, but this is not a surprise to anybody, contrary to any representation she might be trying to make. And considering the unless her victim is in the hospital and unable to respond, then I don't think that it's necessary to wait for a whole another week, especially when I have other judges waiting for this decision.
Well, here's what wasn't known before.
And I've spent 5 months trying to resolve this.
This consent of surety was filed today. Okay.
I know that one was, John, but we've had that available and ready. Every time we've had a hearing, there has been somebody in the courtroom with a fresh dated that day consent, but they've never been able to do the hearing. So while it might appear that this is the first time that this question has come up, that's simply not the truth. And I think my lawyer can represent well that this has involved dozens of people. We've earnestly been trying to resolve this issue, and I do think it's a little bit disingenuous for the people to say we didn't know, because they certainly did.
All right, Mr. Brandt. What you and your lawyer have known or thought you were going to do numerous times isn't the question. The question is when the people and the victims knew this. They could not have known it any earlier than today when this was filed. So that's they are entitled to respond to this.
So they did know, and I just want to make sure the record.
They do not know.
I don't think another week is necessary. I think they could easily accomplish this by Tuesday.
You've voiced your opinion, and I'm not going to agree with you, and don't argue with me anymore about it. Okay?
I appreciate it. Thank you.
The victims have 7 days if they care to respond. I will vacate the judgment on this now if you want me to. It is so ordered. Because, again, that's just a matter between the people and the bondsman and collecting money from them, and it appears to me that it's clear that Mr. Brandt was not available at that time, and the bondsperson should not have a judgment entered against him. The only question then will not be a consent of surety, just so we're clear, Mr. Kellen. It will be, after I hear from these witnesses, either I will leave the bond at $50,000 or I will reset it at $20,000, in which case the bail bondsperson will have to put up another bond. Understood?
I appreciate it. Thank you.
All right, Mr. Brandt. What you and your lawyer have known or thought you were going to do numerous times isn't the question. The question is when the people and the victims knew this. They could not have known it any earlier than today when this was filed. So
Judge, I do understand that. I would, however, request that if what we're doing is vacating everything from the original bond, and then the issue is whether the court keeps the current set $50,000 bond, or if the court issues a new bond, I would ask the court to consider bonds other than just what was previously authorized in this case, if we're talking about a new bond.
Well, I'm not inclined to reconsider that because, again, I do have the big picture here, and although, again, because it's a motion to revoke based on a subsequent offense, I've told you my reasoning on the PR bond, but I'm not going to reduce the $20,000 bond, no. And so the people or the victims will have until the 29th to file any objection. If that doesn't happen, or they, I'll consider their objections, whatever they might be. Now, does the defense want an opportunity to respond to that, or you want me to just go ahead and deal with it at that time?
Well, Judge, what I would request, if we're waiting until the 29th, I would request that we actually schedule another phone appearance such as this one for the 29th. I think that if there's no objection, if it's going to either reinstate or grant a new $20,000 bond, that's something that would be very quick. But if there are objections, I think it would certainly expedite the process if I'm allowed to address those and argue those in an appearance like this, instead of waiting for another week or even a few days after that for a written response from those objections.
Okay. So again, I'm sorry, over the phone, I'm not catching your name real well, whoever's clerking this. I got to say, this has not been a very, and I'm not trying to be critical, I'm just saying what it is. This has not been a very smooth process here to conduct this proceeding today. Maybe it's because it's in with all the rest of your appearances. If you could set this at another time, it would sure help, other than what your other appearances are. Can you do that next Friday?
We can schedule it in another courtroom, so when you can look at the R2 docket.
Well, it's not going to make any difference to me what courtroom it's in if I'm going to do this by phone. I mean, it could be in a conference room as long as it's open to the public, but can you do it?
Yes.
What time can you do that?
Let me look at what we have set next Friday in our docket.
I'm sorry, I'm having a real difficult time hearing you.
I'm sorry, I'm not by the phone. How about like late morning on Friday the 29th?
That's fine with me.
11 or 11:30?
Either one. Counsel?
I can be available at any time on Friday.
The prosecution is available anytime, Your Honor. We would defer to you.
And Mr. Brandt, it's hard to say about Jefferson County and they're getting you on the phone and all that sort of thing, how much cooperation we can expect from them or what sort of orders they want. You understand that?
Your Honor, the Jefferson County facility has been very accommodating, and it's actually been working out quite well from my perspective on a number of different jurisdictions. So I think Mr. Kelland knows how to speak with Sergeant Williams, and they can set something up pretty easily.
Okay.
That is correct. And Your Honor,
Go ahead.
Your Honor, I apologize, but I would agree with Mr. Brandt. I think that the Jefferson County Jail has done, frankly, a better job than I expected of accommodating and making sure that people are being put in a position where they can either make a phone call like this or do WebEx.
Okay.
I'm confident that if we let them know, that they will be able to accommodate that.
Okay. And you'll take care of that? You and Mr. Brandt will take care of that?
Yes, Judge, I'll take care of that.
Okay. So, I'm sorry, did we decide on 11 or 11:30?
it doesn't matter to the defense.
11 a.m.
11 o'clock.
Yes.
That's fine. Thank you.
All right. Two more things. One,
Yes.
whoever's going to clear this, could they get a hold of me? It's not impossible for me to do WebEx. I just didn't have a heads up on that today. So if I could talk to somebody next week about this beforehand, that would be helpful. Secondly,
And Your Honor, I apologize, Mr. Kellen, for Mr. Brandt. I would make the same request if I could also be included on that communication. I would like to thank the district attorneys for their efforts to help assist in getting in contact. But there was a lot of confusion from me and from Mr. Brandt on exactly how we were supposed to contact and who we were contacting. And I am capable, and so is Jefferson County Jail, of handling this through WebEx, if that's how the court would prefer to do it instead of phone calls.
I honestly, I don't have a problem with phone calls, but the key here, and obviously staff for the court is diminished, and it gets passed around to whoever happens to be available that day and that sort of thing, and that's just the way it is. I mean, it's unfortunate, but it is. So I'm just saying either way is fine with me, and if someone could possibly get a hold of all this, Tuesday or Wednesday, Monday's a holiday, so that we can get this squared away, I'd appreciate it. But I've got it down for 11. Now, one more thing. Do the people want a protection order entered in this new case? Or?
Yes, Your Honor, we do think that is appropriate, listing all three of the named victims.
Right. I think it's essentially required. So,
as far as the defendant was concerned, I thought the protection order already existed, so.
I don't think so, because you should be personally advised of that. So a protection order is ordered concerning the victims, Mr. Bonder, Ms. Crespin, or Judge Crespin, and Ms. Betts. So you cannot contact them in any way. You've got to stay at least 100 yards away from them. I'm not in saying that implying that you intend to do either, but those are the terms of it. Understood?
Yes, sir. Yes, sir.
Okay. Anything else from any party?
Matt Kelland, are you going to call me through the jail, or do you need me to call you?
Eric, I can give you a call when we get done with this proceeding.
I'll call you when I get done here, then, yes. Thank you.
Actually, Eric, why don't you stay put, and I'll just call you right back.
That's perfect. Okay.
Your Honor, from the defense, the only other thing that I think we need to do is, if the court would like to pick the following court dates on the 29th, that's okay with the defense. If the court would like to set them now, we can do that as well.
Either one's fine with me. What's people's preference?
The prosecution would be asking to set those dates now, so that way we can notify the other three jurisdictions to try to avoid any conflict of dates.
All right. Let's set that now, and let's see if we can't get word to Ms. Easton between now and next Friday about that date we pick, so to find out if that's going to work for her. Okay?
Thank you, Judge. And I can contact Ms. Easton. I apologize that
this
dogs hear something outside and then they go.
This is what we have while we do these things this way. So, okay. So, what are you looking at? July? You want them further out than that? What from the council standpoint?
What are we going to set it for? Are we setting it for an arraignment, or are we setting it for a PH?
We're setting it for possible disposition on both cases.
Okay. You can do it whenever you guys want. If you want it in June or July, just let me know, and I'll look at dates.
I'm not sure I heard what you said, but I thought you said July's okay. Is that correct?
Yes, that's what I said.
Okay. So from the people in defense standpoint, you tell me, did you want it 60 days out? You want it further? What are you looking for here?
Your Honor, I think that the prosecution... Oh, go ahead.
Oh, no, I'm sorry. Go ahead.
I was just going to indicate we think that later, the last part of July would most likely be more effective. If the defense thinks they need more time, just let us know.
I certainly think that, I don't want to go any farther than, sometime in July, even if we don't have anything completely finalized. I would prefer to come back in July, and even if at that point our information to the court is we are getting close, but we're not quite there.
How about the 24th or the 31st of July? Are those dates the court could accommodate this?
Yes, either one is fine.
Okay, again, I'm not hearing very well, but I think I heard you say yes, and then the question would be what time. Counsel, you have preference on those days?
Let me check my calendar. Frankly, neither of those dates are very good. Would it be possible to do a different day, the week of July 20th?
The reason
I can be available. Oh, sorry, go ahead.
The reason I try to do them near the end of the week is it tends to not conflict with other senior judge assignments. In other words, I'll get called to do a trial, but it'll be the first 4 days of the week, that sort of thing. Right now, I don't have any there, but I expect there's going to be sort of an avalanche of these things pretty soon. So.
Well, Your Honor, in that case, I can accept the late afternoon of the 24th, but I have a pre-scheduled appointment that I need to be at in the morning and early afternoon.
So what time?
Your Honor, I would request something 3:30 or later.
Can you make 3:30, or are you just trying to be hopeful you'll make 3:30?
Your Honor, I can make 3:30, but
right.
I don't feel comfortable setting any sooner than that, or any earlier in the day, rather.
3:30 work for the people?
It does, thank you.
Hold on. Can we do the 31st, July 31st in the morning, like later in the morning? Would that be better?
No, I'm out of town that week.
Can the court do 3:30 or not?
You know what, I'll just set it on the 24th at 3:30.
That is the time and date that's been suggested.
Okay, we'll do it then.
That's good?
Yes.
Thank you.
Thank you.
All right. So we'll be talking next week, I guess, if we find out that, again, that doesn't work for Ms. Easton or something else. But for now, we'll plan on that. So anything else anybody needs?
Nothing else from the defense, Your Honor.
Nothing from the prosecution, thank you.
Okay. Thank you. And if, again, from the clerk's standpoint, whether it's today or early next week or something, if somebody just give me a call or send me an email, we'll work out the details of this.
Judge, okay?
Thank you.
You're welcome, thank you.
Bye now.
Thank you.
Thank you.
Are the parties to the Whipperidge matter on the line?
Your Honor, I believe we are all on the line.
I'm sorry?
Yes, I believe so.
Who's on the line?
This is Kate Armstrong on behalf of the people.
Thank you, Ms. Armstrong. This is, Mr. 20 CR 1493, Michael Whipperidge. I'm sorry, the court is calling Michael Whipperidge. I'm sorry about the delay. There's a senior judge case that needed to be handled. I was not able to handle it. I scheduled this hearing at 3, hoping that it would be concluded, but it wasn't. So again, I apologize. Who else is on the phone?
I'm here, Michael Whipperidge.
All right, good afternoon, Mr. Whipperidge. Mr. Blazewith, are you there?
I am, Your Honor.
Okay. This matter is set for a